to him.
And you have access,
Well,
exactly.
I must say we have limited access. Limited access. You know, it's a team. We have limited access. There is no access as better than when you can confer with your client in the comfort of your chambers. That's my definition of client-lawyer relationship. Not one that I will go into confinement, you know, and I'll be restricted in discussing with my client, as it were. There has to be freedom of communication. And that's where it is, and that's why the person has been admitted to bail.
Where is he at the moment?
Can you confirm the location?
Well,
is it Lagos? Is it
Well, the truth of
Abuja?
the matter is that the DSS will come and tell us that, because I don't work with the DSS. Because even if I tell you he's here today, he could be taken somewhere else tomorrow. So I need to be very careful. They should come and tell us where he is.
Well, you've seen him physically since the last hearing.
It was with me here the last time. It was with me here, and I'm sure some members of the team equally have access to him. But I saw him personally last time when I was in court here. And I have not made any further attempt personally to see him. But I know very well that he desires to reunite with his family. He desires to face his trial in court. He desires to be here. He has assured the court that he is not a flight risk and is going nowhere. And that is just the truth. Ex-CBN governor, cerebral bank affairs, and so many other things that will make him not a flight. In any event, let me even tell you, the position of the law now is that there is a statutory disincentive for people to even abscond from trial. You know why? The ACJA has a provision that if you abscond, after you are admitted to bail, trial can continue in absentia, and you can convicted. Who will take that risk? If you mean that your evidence is uncontradicted. So there's a statutory disincentive. The DSS should come and tell us the reason. There is a court order and they should obey it. If they don't want to obey the court order, they should not ask for favors from that same court. That's our position. And let the court decide. I won't go into the medicine application. Thank you. Well, what happened today? There were two applications that were brought to the notice of his lordship. The first application is the one filed by the federal government, which in the main seeks the leave of the court to appeal the decision of the court admitting Godwin Emefiele, the defendant, to bail. That application is within their prerogative to file. That application was served on us, and we responded to that application as an application that should be adjudged meritorious. We qualified our own application, which seeks in the main to prohibit further prosecution of the defendant, Godwin Emefiele. And of course, equally seeks an order of court restraining the federal government from seeking further indulgences from the court by reason of flagrant disobedience of the court. So our application calls into question the powers of the court to protect and preserve its orders in the interest of constitutional democracy. Whether once an order is made, in my humble view, it does not lie in the mouth of any person by reasons of clear provisions of the Constitution to stay in the comfort of their bedrooms to disagree with that court order. There are proper means for ventilating a grievance against a court order. You could take vertical proceedings by virtue of taking an appeal against it, or take horizontal proceedings by coming before the same court and showing reasons why that same court could be invited to revisit its order and set it aside. These are principles of law. So when those both applications came up for hearing, came up today, the federal government was of the view, and they're entitled to have their view, and they tried to convince the court that their own application should be taken by a simple reason that they filed first. But we were of a different legal persuasion, as priority of applications is not determined, in my humble view, by when you file, but by the substance of your application. If you are saying that a contemnor is not even entitled to be heard, You are saying that even the application that they have before them is not meritorious in the sense that they should not even be heard until they purge themselves of the content. Then it becomes very important for the court to determine whether our own application is meritorious. If the court finds that, well, given the circumstances of the case, let us listen to the federal government even though they are in disobedience of court order, then of course, their own application will be right for hearing. But until that application is heard one way or the other, I think justice will not be met if the court had allowed them to move that particular application. And his lordship, in his lordship's view, agreed with that position that the justice of the case will be met if both applications are taken contemporaneously. And the reason why the application was not taken today, as regards our own application, was that despite the fact that we served the federal government on the 8th of August, and was only served with their response today. And I'm not a mobile or encyclopedia of the legal profession. I need to look at what they have said, discuss it with the team, and we'll come up with a position. And we simply ask the court to give us just 1 day to respond. In any event, we do not see any harm in that because Godwin Emefiele, as of today, is still in detention. So we are still suffering the injustice of non-compliance with the court order. And that is actually what we seek to protect. So these applications actually takes to the front burner the powers of the court and the need for the court to look at whether it would protect its orders by its coercive powers, constitutionally and statutorily provided, and even endorsed by case law, which you have cited. But gentlemen, I can't go into the merits of the application because I'm not entitled to do so, but I just wanted to let you know that's what happened. So there was a ruling, and the ruling simply said, let us check both our applications. You can't take this application